recording today's session. So to ensure a quality recording, we are keeping everyone on mute. We will allow for time at the end of the session today for questions. However, if you wish to submit your question at any time, feel free to use Zoom's chat feature. And with that, I will turn it over to Richard.
All right, good afternoon, everyone. We sincerely appreciate you joining us for our second Riparian Rights update for Florida. For those of you who are around the first time, we spent a lot of time talking about what riparian rights are, when you have them, how to draw the lines or riparian lines. And then after we've determined that you have riparian rights, we've drawn the line, we've then had a significant discussion on how neighbors essentially interact with each other regarding riparian interests. Today, we're going to do a little bit of a refresher, but after that, we're going to discuss what happens when things change, particularly when ownership changes, or maybe when the lots change, or, and more specifically, or probably the biggest issue is when the shoreline changes. So we'll go ahead and get started. And so what are riparian rights? Again, we discussed this, but typically when we think of riparian rights, people think of boating, they think of docks, fishing, things of that nature, maybe even the issue of navigability. But riparian rights are those rights that are incident to land bordering upon navigable waters. And the specific rights are laid out here: ingress, egress, boating, bathing, wharfing out, and view. It's also important to note that riparian rights are subject to the public's superior right of navigation. Now, in Florida, riparian rights do come from common law, but they have been codified. So again, this is the statute, section 253.141. And again, it's noted there that riparian rights are those incident to land bordering upon navigable waters. So navigable waters is an important distinction. We've collected the Florida Administrative Code, Chapter 18-21.003, which is the definition of sovereignty submerged lands. And navigable waters is important because navigability is determined at statehood. So not every body of water in Florida is categorized as a navigable water. So it is an important distinction to remember regarding that. So when do you have riparian rights? Okay. Obviously, probably the biggest piece, the 30,000-foot view, is you have to own land that touches the water. Okay, again, it has to touch navigable water body. There are no riparian rights in an artificially created, privately owned water body. No dredged out canals, no man-made lakes. Now, for purposes of the first case study we're going to look at, it's important to note that it's possible that you can own less than fee ownership or not have total ownership of a piece of land, and you still may be able to claim riparian rights. And specifically, there's a citation there for you all, 18-21.0043B. So, do you have riparian rights? And the first case we're going to look at is, we've called it Shore Village. It's in Martin County. And with that, I'm going to pass it off to Kevin Hennessy.
Thank you, Richard. So the first slide we have is with regard to the Shore Village property. This case study that I'm going to discuss actually did go up on appeal and was decided for any attorneys on the call. It was Shore Village Property Owners Association versus State of Florida Department of Environmental Protection, 824 Southern 2nd 208. The 4th DCA 2002 case. This, in fact, was one of my first riparian rights cases that I handled. And it involved two issues, and that was, did a shared easement for a community road convey riparian rights to the interior lots in a community? And if so, did it include the right to build a dock? So in 1964, what you had was a single parcel of property. It was owned by the Hutchinson Isle Land Company. It was about 200 feet of shoreline, and it ran from the waters of the Indian River to A1A. So we can go to the next slide, Richard. So this is a blow up of the subdivided lots. You had, it was divided into 11 parcels. You have, of course, 2 parcels on the Indian River, and then the 9 parcels that were upland. And down the middle, you had an easement, and it was a 10-foot easement on each of the lots. So 10 foot on the lots on the one side of the center, 10 foot on the lots on the other side. So you had a combined 20-foot easement running down the center. Now there was no, this was not a platted community. It was all just subdivided. So the 2 riparian lot owners on the river, they did the northern property owner. He had a dock from the very early on. The community also in these lots. Well, the property was a single piece of property in 1964. It was subdivided in about 1968, and in 1971, the community built a small dock at the end of the road. That dock fell into disrepair, but in the 1980s, it was rebuilt. It was in fact repaired and extended. But again, in 1993, the dock was destroyed by a storm. Again, they repaired it, but it fell into disrepair. And if you go to the next slide, Richard. No, this is out of order. Thank you. This is the 1999 aerial. What you can see is the community. You can see Shore Village Terrace is the name of the road that runs down the middle. And in fact, you had no dock in 1999 for the community. The dock that you do see there is on the northern property that was owned by Mr. Wadner. And the southern waterfront property was owned by a gentleman by the name of Peter Anania and his wife. And they, about the same time, planned to build a dock. But in 1999, the community had plans and a signed contract with a contractor to build a substantial dock with individual boat slips. And the waterfront owners objected. Construction was stopped because they had no Department of Environmental Protection permit. The community went to the Department of Environmental Protection for a permit, and that permit was denied based on the fact that from the department's perspective, there was not sufficient evidence of sufficient upland interest, meaning that they looked at the easement, the road easement, and did not see entitlement to riparian rights under that road easement. DEP also stated, though, that this was a matter for the circuit court, which has sole jurisdiction to decide property rights. So now if you go back to the slide with the easement language. All right, so this is the important language that was contained in the easement on every one of these subdivided parcels, that it stated that the property was granted to the lot owner together with an easement and right of way for road purposes. So it, the belief that it was actually a road easement, but road purposes over, on, and under the following described parcel of land extending from the west right of way line of State Road A1A to the waters of the Indian River. And the language to the waters of the Indian River was, of course, what the community was relying on for the belief that they had riparian rights. Now, this language was similar to other easements where, frankly, no riparian rights or no right to build a dock was found. There was a single case from the second DCA by the case of Cardish versus Soper, where riparian rights were held, and there was a right to build a dock where a plat specified the existence of a parkway, and that parkway provided for ingress and egress to the waters of Boca Ciega Bay. So not quite the same, but certainly clearer language of an intent for the use of waters in that case. In any event, the upland owners brought suit for declaratory judgment against the DEP and the waterfront property owners. We represented the waterfront property owners, Mr. Anania and Mr. Wadner. The DEP, in fact, was dismissed before trial. It was a 2-day trial, and the trial court ruled that the easement provided for riparian rights, including the right to build a dock. But they did determine that the proposed dock, and it was a dock which was providing slips, boat slips for all of the individual property owners. They determined that proposed dock exceeded the easement and unreasonably increased the burden on the waterfront property owners. So the waterfront property owners got some relief from having a community marina built between their, right on their property line. The appellate court heard this case and agreed with the trial court. So if we go to the next slide. So what we have today is, in fact, 3 docks. Mr. Wadner's dock is at the top. The community dock is here in the center. And on the bottom are the Anania's dock. From the trial court and the appellate court's decisions, it's clear that the courts looked at the language of the easement, but also looked at the history of the community activities, the fact that the community had previously built and maintained a dock. And so in ruling, the trial court and the appellate court fashioned a solution that it thought equitably split the riparian rights of the waterfront property owners and the upland lots in the community. So as indicated in Richard's preface, riparian rights are going to be very dependent on the on showing that you have property that's touching the water, and the water being a navigable water body, but it's also that interest can be, in this case, a less than fee, such as an easement that is benefiting upland property owners. And again, I think it spoke to the fact that the property was all owned at one time and divided up with somewhat of a common development plan. The next case study, in this case, is currently on appeal to the 4th District Court of Appeals, deals with a property in Palm Beach County. The property is Wellington Arms Condominium, which is pointed out here in a nice red arrow. The condominium is that kind of C-shaped buildings with surrounding an interior pool. You can see that along the waterfront of the condo, there is a dock that runs the length of the waterfront. and has several slips for the availability and use by the condo owners. This case surprisingly deals with the issue of the existence of a navigable water body. And of course, clearly you can see in this picture that you have a navigable water body, but as Richard indicated, the date of importance is not navigability today, but navigability when Florida became a state back in 1845. So this, while this property today sits on the Intercoastal Waterway, and the part of the waterway known as Spanish Creek, which is south of the Lake Worth Lagoon, and just the lagoon ends, or the Spanish Creek ends right about, if you look in the corner of the picture, you can see the parking lot for the City Hall for Ocean Ridge. If that helps anybody get oriented. Community docks had been there for decades. And in fact, the community had a state lands lease for use of what was identified as sovereign submerged lands. And that continued until 2015, when the DEP was contacted by an individual by the name of William Swaim. The department thought that Mr. Swaim was a Wellington Arms resident because he was contacting them and arguing with the department that the docks were not on sovereign submerged lands, but and that at the time of statehood in 1845, there was no water body in the area. The department received a lot of information from Mr. Swaim and determined, based on its review of that information and the archives that are maintained in Tallahassee of all the old surveys that were done at the time of Florida became a state, determined that they could not definitively state, based on the information they were looking at, that the land in question was in fact sovereign submerged lands. So the department voided the lease and returned the lease fees paid by Wellington Arms. Wellington Arms was frankly misled, thinking that they were getting a benefit to their community, where in fact what they had was an individual who was looking to claim private ownership of the submerged lands in this area. So if you go to the next slide. So Mr. Swaim he calls himself a developer, and he purchased the land that you can see on the left hand of the picture, which has a mangrove island, and it's right, exactly. Thank you, Richard. And he also obtained a quitclaim deed from the original developer of the Wellington Arms property for all of the land. And in the quitclaim deed, they quitclaim to Mr. Swaim all of the land west of the platted subdivision that created Wellington Arms, specifically including all of the submerged lands west of the platted subdivision. Mr. Swaim then brought suit, well, after sending a letter to Wellington Arms telling him that they need to remove their docks from his private property. When they did not do that, he brought suit to quiet title to the submerged lands, suing Wellington Arms. Wellington Arms subsequently got the DEP involved in the case and defended the claims based on the fact that taking the position that the property, one of the defenses was that the property was in fact sovereign submerged lands, and the lease should not have been voided. Now, if you go to the next slide. Okay, so the next slide, what you see is the information that Mr. Swaim was primarily relying on, and this is the official government survey completed to determine what lands Florida had received when it became a state, and also specifically identify the waters, sovereign submerged lands, or navigable waters that existed at the time of statehood, because those navigable waters would be owned by the state. You note that it's a 1872 survey for lands that were acquired in 1845. That's just gives you an idea how long the survey process of Florida took. Of course, you had people, trying to fight their way through the swamps of that was Florida at that time. So what you can see in this original official map is you can see the Lake Worth Lagoon is the water body up in the north, and coming down from Lake Worth Lagoon was Spanish Creek. And here, I think Richard's giving me control. I can try to get control here. There we go. So this is Lake Worth Lagoon here, and then this is Spanish Creek running to the south. And this is the area where the property Mr. Swaim was claiming ownership of existed in the Wellington Arms. So you can see, and there was no question that this map, the official map, did not indicate the existence of any navigable waters in the area of the properties in question. This map is not supposed to be definitive of the question of navigable waters, but it does create a rebuttable presumption because no water body was indicated, and more particularly, no water body was meandered, and meandered meaning that is a navigable water body. Now, what Mr. Swaim was arguing was that this demonstrated no navigable water, that the existing navigable waters were all based on substantial man-made changes affecting and extending Spanish Creek in the time period from 1845 to the present. So you go to the next slide, though. You've got an 1841 map of Lake Worth, and you have a different story. And this map, of course, predated Florida becoming a state. And you have, again, Lake Worth Lagoon depicted, and Spanish Creek. And Spanish Creek would actually extend to the approximate location of the properties in question. So this is some of the contrary evidence that that was produced by Wellington Arms and the state of Florida. If we go to the next slide, we have a similar 1884 Coast Guard geodetic survey showing again Spanish Creek, and it shows the Wellington Arms property bordering that creek, and certainly this would be at a time period before any sort of man-made influence or substantial change occurred to these navigable waters. So there was quite a bit, and this is just just a sliver of all of the kind of survey information, historical reports, surveyors' notes, and other historic information concerning the area that was presented to the trial court. The trial actually was held, ultimately involved only DEP. A settlement was worked out between Mr. Swaim's company, Waterfront Property Owners, and the Wellington Arms condominium folks that is affected by the ultimate outcome of this case. The DEP went forward with a trial. They were not successful. The court found in favor of Waterfront ICW Properties that the 1872 map was controlling, and that there was no navigable waters in 1845, and that the property was privately owned. As I indicated, this case is currently on appeal in the 4th DCA and should be a very significant decision concerning riparian rights and the termination of riparian lands. Because interestingly enough, Mr. Swaim, he's basically has a business of this now, and he's not the only one that's going up and down various water bodies like the Intercoastal Waterway and finding private deeds to submerged lands and looking to purchase those lands and sue for damages for anyone who might be trespassing on those lands, such as cable companies with underground cable lines. So that concludes the second study, and with that, I'll turn it over to Mr. Bauman.
All right, so you've seen a couple of case studies that deal with the initial question, rights, which obviously is usually tied to having land that touches navigable waters, Kevin went into. So the next question, assuming that you do have those rights, is how do you draw those riparian lines out into the water that define where in the water you have riparian rights? So I'm using a slide here, which is a good example of this. This is up in Sewell's Point in Martin County. And you see a series of docks here, but there's some disagreement where all these docks are pointed. A reason for that, the reason for that is essentially use of different methods for drawing the riparian lines, which typically occurred or fell in and out of favor with the surveying community over time. So the result is, if we can go to the next slide, Richard. The result is that we have two competing riparian right solutions here. The first is you have a solution that involves the yellow box, I'm going to call it here. And you can see that that is essentially taking the side lot lines of the upland properties and drawing them out into the water to define the riparian rights. And you can see that the docks to the north here align pretty well with that methodology. The second is a riparian line that is drawn as illustrated in the blue box, which is drawn in another fashion. So in this case, we have the Indian River. This is a very wide part of the Indian River. It's nearly a mile across. The marked channel is very far offshore from this location. And these folks here are often wharfing out these long distances just to get a few feet of water to launch a boat. So the blue box is actually indicative of another riparian solution called where you're drawing the lines perpendicular to the shoreline. In many cases, you'll see methodologies drawing perpendicular to the shoreline, perpendicular to the channel, whatnot. The reason for this is that at one point in the distant past, the favored methodology was to extend the lot lines, similar to the yellow box. The Supreme Court has rejected that notion as being an appropriate method for drawing riparian lines in the case of Hayes versus Bowman, which is an old Supreme Court case from a number of decades back, where the Supreme Court basically stated that the shape of the upland lot, the shape of the side lot lines of the upland lot, really have no control on the intent of riparian rights, which is to allocate up this shoreline in a fair fashion to get everybody from the shoreline to the point of navigation, whether it be deep water or a marked channel. And therefore, the line should be drawn with two things in mind: the shape of the shoreline and what they refer to as the arm of the sea. And you're supposed to be able to get from one point to another. So in this particular case, you can see we have a dock up at the top here, which was the dock in dispute, which is drawn using the old method, extending the lot lines. And then we have a dock to the south, which was laid out at a later date using what is now considered to be the correct method. What wound up in this case was that you had three lots in the middle that were closed off by this differing methodology. These lots, they couldn't extend out to the deep water because they were pinched between these two docks. If we can go to the next slide, Richard. Oh. Okay, so what we've been referring to is the guidance for setting riparian lines. Now, what we have here is a page out of what's been referred to very often as the white paper. This is a paper that was originally put together by the late Dr. David Gibson, who was a surveying professor at University of Florida. And what Dr. Gibson did was that he took essentially a survey of Florida case law, setting riparian lines and discussing methodologies. And over the course of this study of Florida case law and Florida case law development, he essentially assembled that into this guideline book on how to set riparian lines in different situations. So I've used this page here because I think it's a good illustration. We have a series of different shorelines here. Up here where it says North Shore, you can see that there's a very gentle curvature of the shoreline here, back and forth. It's not straight, and it's not even close to being straight, but it's not what we would refer to as irregular in this location either. By contrast, in where we see Cove B, we see that that's a deep cove, and followed by a headland out at the end here, where it says F and G, and then Coves C and D are what we refer to as hidden coves. And they're extremely deep coves, often with a turn or a bend in them. And you can see that as you travel over this length of shoreline, our riparian rights methodology changes. We have a line up here that kind of travels along the shoreline, if you will. We refer to that as the line of deep water. And then we have another line down here, which is this dotted line, which is the marked navigation channel. Now, at the end of the day, the real role of the riparian rights is, in the presence of a channel, would be to get people from these upland lots to this channel so they could then navigate to wherever they want to go. But the shape of the shoreline and the arm of the sea dictate that the lines have to be drawn a little bit differently in different situations. So where you have a relatively regular shoreline, such as over here in this North Shore area in Cove A, you will see that the riparian lines pass through the line of deep water and transit all the way to the channel where they meet the channel in a 90-degree angle. And that is the preferred riparian methodology. Now, this would occur regardless of how the lots are shaped. The lot lines could extend off on 45-degree angles. They could be triangles. They could be flag-shaped lots. It doesn't matter. But the point of the riparian lines is to parcel out a clear area or path from the upland, from each upland property to the accepted point of navigation. In this case, the channel that's designated for that. When the shoreline becomes more irregular, you'll see that the methodology, the preferred methodology, is to abandon the use of the channel, because if you drew these lines from, say, Cove B straight down, trying to go perpendicular to the channel, you would run into problems, particularly on the sides here, where the lines would essentially put riparian area in people's backyards, in neighbors' backyards. So when you get to the irregular shoreline, such as in Cove B, and you can see in Cove C, you abandon the distance to the channel, or the direction to the channel, in favor of just getting folks to deep water, which you see marked in this dotted line here. Because this is a cove and essentially it's cut up like a pie, the goal is that if you have a lot with a distance, such as these two lots under the word cove in Cove B, that have shorelines that are, let's say that this lot under the C and the O in Cove has 100 feet of frontage, and the lot next to it has a 70-foot frontage. The goal would be to try to draw the line so that when you reach to deep water, the width of the riparian area would be 70 feet, and the width of this riparian area would be 100 feet. But recognizing that the cove won't allow that, because at some point you will pinch somebody off at the corners, you're forced into some form of reduction of the riparian area as it extends out into the water. And this is typically done through essentially a prorating, if you will, of the width of the riparian area when you finally reach the deep water, such that perhaps all of these lots take a 10% or a 15% reduction from the shoreline width to the deep water width of the riparian line. When you finally get to the hidden cove, such as in Cove C, you will see that often what has to be employed is an additional surveying exercise by inserting in here essentially a thread or a center line of the cove to give you an endpoint to aim the riparian lines at, to essentially get to deep water, but make sure that nobody is closed off from accessing and navigating essentially along this center line. And the center line is particularly used, as you can see, to parcel up the riparian areas, these 5 lots that we see in the back of the hidden Cove C, to parcel them up so that each of them has a piece of the deep water to access and get out to without running into somebody else's dock. What is interesting, though, is that between these coves, you will see that even on headlands where you have a few lots, let's say on the headland, that whenever possible, you try to return to that perpendicular to the channel. Often you will see you have lots that have a little bit of both. So when you have a relatively straight shoreline that maybe transitions into a cove, forming a point, your lot owner may have a riparian line on one side that is perpendicular to the shoreline, and may have a line on the other side that is the line of deep water, such as this lot A right here. We go to the next slide, Richard.
Actually, we have a question. How does the Butler Act play into this issue?
That's right. I apologize. We had a question raised earlier. So someone has asked, how does the Butler Act play into drawing these lines? And I would say overall, the Butler Act does not. And the only reason for that is that the Butler Act, for those of you that may not know, the Butler Act is one of many what we refer to as legislative giveaways. where over the course of Florida's history, folks have built a lot of stuff without asking for permission. And periodically, the state sort of threw up its hands and said, you know what, to go back and figure all this stuff out over the last 10 years or 20 years would just be a mess. If you got it and you built it, it's yours. If you bulkheaded and you filled, it's yours. If you built a permanent structure, it's yours. And the Butler Act was one such giveaway. And essentially, the Butler Act provided that if you permanently improved your property, permanently improved the submerged land in your property, such as the construction of a pier, such as filling, but something with permanence, that the title to that improvement vested in you. The Butler Act was ultimately repealed. And so the test for today is looking back at an old improvement, such as a filled area, a seawall, a pier, etc. The question is, was that thing there before the Butler Act was repealed? Now, the presumption at this point is that the riparian would have built whatever this improvement is within his riparian area, and would therefore be able to go into the state of Florida and get a disclaimer to transfer title of the footprint of that improvement from the trustees over to him via the Butler Act. And that could occur today. For instance, an old fishing pier or something like that that's still there. But if that would transfer the ownership of the improvement, that wouldn't necessarily change the drawing of the lines. So there's at least one case out there that has told us that former sovereignty lands under a navigable natural water body in 1843, even if reduced to private ownership at a subsequent time, still carry riparian rights over to the riparian owner. So you could conceivably have an individual who has a strip or a footprint of a dock or something that's a footprint of an improvement that extends into the water body, that they might have title to that submerged land. However, if that happened to cross a riparian line of his neighbor, the argument could be made that, and assuming that the riparian line is actually set by a court or in a deed, the neighbor will still have riparian rights across whatever portion of that private submerged land that the Butler Act claimant was able to claim from the state. In other words, if you have a Butler Acted strip of land in the shape of a dock that say extended from this lot right here and went this way, such that you have a strip of privately owned submerged land right there, to the extent that this riparian has riparian rights, and to the extent that his riparian line is truly established in a court proceeding, this riparian would still possess riparian rights over that private strip of land in that instance. So it wouldn't really change the direction of the lines. It could be a little different if talking about property that was actually filled and remains in that filled condition as to where we draw the lines, but generally the Butler Act would not. So we're going to look at another case here. We have two other cases to look at very briefly that are examples of something that's been encountered more and more in the last couple of years, it seems. We're getting more of these cases, which is, how do the riparian lines react to changes, sometimes radical changes, in the shoreline over time? The riparian owner, one of his riparian rights is the right to receive accretions to his property. So if the property accretes to the riparian owner and In other words, sand gathers up in a relatively imperceptible rate, and it's not the result of the activity of the owner himself. His property grows. And so the issue comes when the property grows and the shoreline actually changes shape, changing one of the two considerations for drawing the riparian lines, the shape of the shoreline and then the arm of the sea. So the riparian lines can react to accretion where the shoreline actually changes in geometry. So I'm going to hand this one over as an example of exactly how much of a head teaser these cases can become.
Thank you, Andy. And, this is one of probably my favorite histories regarding the saga that this case is under. And we're going to call this Tierra Verde. And so from this aerial, you can see there's a yellow area. And so we're going to watch how that yellow area comes to be, as this is a recent photo. But this area prior to 1960 looked vastly different. And you'll notice that there's this little island right here. It used to be completely separated from what we're going to call the mainland, okay? But because of dense channel here, it eroded the island, and then it decided to reach out and grab onto the mainland. And so the owner, William Colony, okay, so this is Colony Island, and Tierra Verde Corporation, who's going to develop this area over here, had to come to an agreement as to what to do with this no man's land, they termed it. And what they decided when they got to around 1965, and you can see how much land actually accumulated to this connection point, all right? They decided that they were going to do two things in essence. One of those things was they're going to split ownership of this area. It is a kind of a vague agreement, but the more important piece was they were going to create an easement. So Tierra Verde Corporation would give an easement to William Colony to access this island so that he could develop it, okay? Between 1965 and the 1980s, somewhere in there, I believe it was in the early 70s, these two parties actually conveyed this easement to Pinellas County, and it became a road, or it would eventually become a road. And so now this area is split by adding a third owner. Now in the 1980s, Tierra Verde Corporation, as you can see, and this is a picture from 1990, but Tierra Verde Corporation had started developing the mainland. They put a road, highway in here, some docks, and various things. This piece of land right here, they intended to develop as well, okay? And they wanted to keep it waterfront. They wanted to have access to dense channel. And so what happened is this area in the cursor, it actually filled in. And so what they did was they got some permits in the 70s and 80s to dredge it back out, okay? But in the 80s, one of their dredge permits was challenged by the successor in interest, Lucille Colony, who owned the island. Now I won't get into motivations behind the challenge, but essentially the settlement that came out of the challenge was that fine, Tierra Verde Corporation could dredge this area out, but they'd have to deposit the spoil onto the island, making the island bigger. In connection with that agreement, Lucille Colony would basically convey away any and all interest she had in this no man's land north of the conveyed road that used to be an easement that was conveyed to Pinellas County. And so through some clever quitclaim deeds, Tierra Verde Corporation became owner of this area that you see right here, okay? Now, a few years later, or several years later, it filled back in. And what you'll notice, and this is where we're going to discuss what happens to riparian lines when there's such drastic changes in the shape of the shoreline, is this lot that used to be just this little piece here grew to cut off this lot here. And so with that, I'll let Mr. Hennessy discuss what happens now.
Well, since we're running pretty short on time, what we'll basically speak to the fact is that the mainland property is currently in a lawsuit with the owner of the property. Can we go to the next slide? property here that's been developed. What you see is that the owner of the island property subdivided his property and has started to sell lots. And he sold to this one individual who's built, as you can see, a rather large home, taking up a majority of the property. So there's a dispute. Basically, the mainland property was looking to develop his property into a substantial either condo or hotel or some sort of large multifamily use, which of course the individual homeowner there is not looking forward to. And in addition, there was a desire by the mainland property owner to include an extension of marina facilities and access to the water from this corner lot. And so what you've essentially got is a dispute over over this land between the mainland lot and the property owner that has developed there. And what we've shaded in blue is a small area that's clearly seaward of both the historic properties and has not been included in any deed or property appraisers description of lots. These red lines came from the Pinellas County Property Appraiser's Office. So the first issue you've got is, who's going to own the land that's accreted, and then the second is, with regard to the lots that get established, how are you going to draw riparian lines? Are they going to be based on, if you look at the first line to the left, on the far left, are they going to connect to an area, thank you, Richard, that would be consistent with where the settlement was with regard to a transfer of property? Because at that point where Richard just was, that's about the area where, that small square of land was, or alternatively, if you go to say the third line over, is a riparian line going to be much is going to be drawn consistent with the current shoreline, and creating a much smaller riparian area for the owner of the mainland and corner piece. I think that probably the best guidance that I've seen comes from the Johnson v. McCowan case, which states that the rule of law applicable to adjacent landowners' rights in littoral properties, and littoral is basically equivalent to riparian now, but littoral was used for oceanfront property as opposed to lakes and rivers. So anyway, the rule of law applicable to adjacent landowners' rights in littoral properties is that no rule can be laid down as to every situation, since their respective rights must depend in every instance upon the shape of the upland, the arm of the sea, and their relative position to each other. The aim of all rules is applied to the rights of adjoining littoral properties on an irregular shore is to give each, as far as may be, a fair and reasonable opportunity to access the channel. And Andy touched on that in going through the white paper. So if we go to the next slide, thank you. It again details a little more clearly the areas of land that are in dispute, and what we've detailed is our opinion of where the riparian lines, how the riparian lines should be equitably distributed. Let's see if I can take control of this. This line here to the north is certainly not in question. The line that we are suggesting is this line here that goes consistent with the lot line that in fact this owner acquired when he purchased the property fairly recently. And so that's the argument that we're making, were making, was that what the court should look at is the historic dealings between adjacent landowners, and historically, I don't know how I changed thank you. Historically, there was a division along that lot line between the mainland and the island property, and that line should be maintained inviolate. And frankly, it's a line that's consistent with the property purchase made by this residential home. But that's, the type, where you draw this property line, where you draw the riparian lines, the court's going to be influenced on a number of factors. It's going to look at the historic dealings between the adjacent landowners. He's going to look at the recorded instruments, the deeds. He's going to look, in this case, I believe, at the prior settlement between the parties, and also as I say, the activities such as the dominion over the accreted lands that had been exerted by the mainland property owner in terms of dredging those accreted lands over time and maintaining that property and actively excluding people from it and the such. And so with that, I'll turn it over to Andy for another accretion case.
And I know that we're getting right at the edge of time, so if you do have to drop off, we do appreciate you staying in. But if you can, the next case is awfully interesting, and I promise we will wrap it up quickly. But with that, go ahead, Andy.
Yeah, unfortunately, every one of these cases could take an hour by themselves. Andy, you may be on mute.
There we go. I'm unmuted. Sorry about that. So this is a case in Lower Matacumbe Key that involves a subdivision here that was platted in the 1950s. The area in question is this area in the corner here. As you can see, that would be our cove in the riparian white paper. You can see that the lots are aligned in the format. They were platted in the format of a cove. These lots are described as reaching the mean high water line and are clearly riparian in nature. To the south, the other point to feature in this slide is this jetty that you see right here, which was installed around the time that the subdivision was created in order to protect a navigation channel. And what resulted is that this jetty did its job by keeping sand out of this channel, but resulted in sand accreting very aggressively along this stretch of shoreline. We can go to the next slide. Okay, so again, here's the cove, and you can see that the lots are laid out as if they exist on a cove. Let's go to the next slide. This is what it looked like in 1964, and the dispute that arose in this case concerns this house over here. If I can get the cursor to work here, concerns this house. Did I get the cursor? No. There it is. This house over here, over there, and that house over there. There we go. Let's see if I can Yes, and you can see them again here. Richard, why don't you move to the more recent slide? I'll kind of move it along here. And what you see is today. So you can see the effect of the accretion has been dramatic in this location. It makes these properties somewhat unique because where else can you go in the Keys and have a big sandy beach? So the properties in question here are located on the top of the, not the top of the screen, but in the middle of the screen, there's a square white house and then a square gray house, and you'll see a vacant lot in between them. And essentially, the dispute had to do with how to divvy up that accreted land. So if we move to the next slide, you'll see both the accretion and another complicating factor here. So the complicating factor here is this purple boxed area here, which was a deed from the Board of Trustees to the owners of lots 40 and 39 in 1963. 39 is the gray house from the prior slide, 38 is a vacant lot, and 37 is the white house. And essentially 39 purchased 38 and therefore got into a dispute over the location of this riparian line between 38 and 37. The reason for this is that 39 wanted to make sure that 38 had lots of beach frontage so that the lot would be nice and marketable. And he was trying to divide this line up over here between 38 and 37 based upon trying to accommodate for this trustee's deed jutting out into the from 39 into where you see 38. What you see here are riparian lines that were drawn basically through the accreted area as, you know, ignoring this trustee's deed for a moment. Now, the issue that became interesting here was, as you can see, the shoreline changed dramatically in this area. This is 1963 when the trustee's deed was issued, and this is in, I believe, the 80s, and these are more modern day shorelines out here. So the issue came to be that 39 and 38, the same owner, were arguing to draw the riparian line and therefore define the accreted property that 38 owned from this corner and draw a line out that way into the accreted area. The problem is if we can click the red on there, Richard. There you go. The problem is this property right here. So this red area was really what was in dispute. Now, the problem with this is that if you're a riparian owner, which these guys all were, their properties fronted on the Atlantic Ocean when this subdivision was created in 1953. And all this sand has accreted and their lots have grown dramatically. And as the riparian owner, as this sand accreted, their ownership actually extends. As the sand accretes, the land converts from state-owned sovereign submerged land into privately owned upland property because of the riparian right to receive the accretions. It doesn't matter that it was caused by a jetty that a third party built downstream, but the result is that every inch as this beach grew, inch by inch, these lots grew. And when we reached 1963, the date of the trustee's deed, you will see that what the trustees quitclaimed to 39 and 40, first of all, it's mostly on dry land, which means that the trustees didn't even own this portion of what they deeded out in 1963 anymore. They had already lost title to this. And so that's why the trustees give quitclaim deeds, because they're only giving you whatever interest they have. In fact, the only interest that the trustees had at this point that actually transferred is this sliver of land here between the gold and the purple. However, the red, which was described in the trustee's deed, was already on dry land. And due to the operation of accretion, it was already the property of lot 38. So as the lots accrete, the riparian lines convert into side lot lines of the upland property. Now, the interesting thing, if we can move to the next slide, Richard. The interesting thing, as you can see here, is when we get away from the trustee's deed for just a moment, other than the fact that because of the accretion, the trustee's deed had only conveyed property, riparian lines are always drawn from the property corners where they meet the mean high water line. And so in this case, it wound up that 39 was wrong, that the riparian line for 38 on this side has to be drawn from this corner right here, not from this corner up here. But what is more of note at this point is you'll see the riparian line from one surveyed point at the subdivision in 1953 to the next available surveyed point in 1963. And you'll see the line extending in a certain direction because of the shape of the shoreline and the arm of the sea. And as this property grew, this area became owned by this lot, and this area became owned by this lot, and so on and so forth. However, the shoreline ceased to be a cove, and it became a shallower cove and a shallower cove until it's essentially a straight shoreline. So at each point, if you were to do this ideally, if you were to somehow track the shoreline through time, these riparian lines would actually look, they would be curved. They would be arcs, they would look like bananas, whatever you wanted to talk about. But because we only have certain evidence at certain points in time, that is why the riparian lines that were ultimately set at this point change direction and bend to the next surveyed point, which was actually here. And then there was a very minor change from here to here. And then you'll see that there's another change or inflection in the line as we reach here. And in this area, there's actually very small bends in the property as the shoreline changes. So what you wind up with is a very oddly shaped lot in this case that you can see kind of almost like a very shallow backward S, kind of goes like this and then kind of goes like that. And each of the lots you'll see share that same characteristic. And that's the result of the shape of the shoreline and the arm of the sea changing over time in this case due to accretion. We're seeing more and more of this in cases these days as the whether it's more storm events or more modifications of the coastal system by governments that result in accretion and erosion. But the waterfront lots are changing, and we're seeing more and more disputes about where either new property is or when property erodes, who lost that eroded property, this guy or this guy. Ultimately, in this case, what happened is that we reached a agreement on a line that tracked this solution right here. I think there was a minor modification of that solution to get to this point right here to keep 38 out of 37's backyard. But at the end of the day, it's very likely that folks on the phone are going to see more and more of this, because I know we're seeing more and more of it. So presumably the department is, and the surveying community. We're out of time, so we always have more slides and problems to present. But in this instance, I think where we'll just finish off is thanking everybody for joining. We always appreciate everybody's attendance in these things. We appreciate the excellent questions that we receive. Anyone who has follow-up questions that wishes to submit them after the presentation, simply email Kevin or Richard or myself, and we'll be more than happy to dialogue with you guys, give you our thoughts and whatnot. But thank you so much for joining us. I hope everybody is remaining safe And we're trying to continue looking at these issues and whatnot through the whole pandemic. And we appreciate everybody taking their time out to try doing this through Zoom. So thank you.
All right, thank you, Andy. Thank you, Kevin. Thank you, Richard. This is Kelly. I just wanted to remind everyone that we will be circulating a copy of today's presentation and the recording. And like Andy said, if you have any questions, don't hesitate to reach out to us. And we hope you have a great day. Thanks.
Thank you, everyone.
Thank you, folks.